Hi, everybody. Thank you so much for being here. My name's Sarah Murtada. This is Allie Johnson from the Community Justice Project here at St. Thomas. First, I want to just say thank you. Thank you for taking time out of your busy day to be here and learn more about no-knock warrants and how they impact our community. I also want to say a huge thank you to the Murphy Institute for giving us the space to have this talk and talk about how no-knock warrants impact the ideals that we hold here as a Catholic university. For anyone who wants to get CLE credit as well, sign in over at the welcome table. You can put your attorney number and you can get 1 hour of CLE credit for this. Additionally, we are going to have a 20-minute Q&A portion at the end of this talk. However, we're going to be collecting questions throughout, so you can write them on the sheets of paper at your table. Over here, these two will be collecting questions, and then we'll ask the panelists the questions at the end. I want to talk a little bit about the history of no-knock warrants. They started in the 70s during the Nixon administration war on drugs era. The reasoning behind the start of no-knock warrants was officer safety and preservation of evidence. Most of that evidence is drugs. So typically, there's a knock and announce rule for warrants. Officers must knock on the door, announce themselves as law enforcement. They must wait a period of time that's typically about 30 seconds for somebody to have the opportunity to answer the door. And this must occur during daylight hours, which in Minnesota is 7 a.m. to 8 p.m. No-knock warrants are an exception to this policy. Officers don't have to knock. Sometimes they might knock and announce, but immediately barge in without waiting that 30 seconds. And they've been controversial since the onset. More recently, Breonna Taylor in March of 2020 in Louisville, Kentucky was killed during a no-knock warrant, and that really brought the spotlight to the country about no-knock warrants. And there was a group of students here who realized that the same systems that failed Breonna Taylor in Louisville, Kentucky also existed here in Minnesota, and so they created Knock First Minnesota to educate and ultimately ban no-knock warrants in Minnesota and Minneapolis as a whole. So then we began planning, as part of that educational piece, we began planning this CLE in November with the Murphy Institute. During our planning session, Amir Locke was killed in February during the execution of a no-knock warrant. And this discussion has taken on a whole new spotlight since. So I want to move to our panelists and give everyone an opportunity to introduce themselves. And Representative Athena Hollins, can you introduce yourself first?
Sure. Can everybody hear me? Okay, fantastic. Hi, I'm Athena Hollins. I am a freshman representative representing 66B, which is the northern neighborhoods of the city of St. Paul. But maybe more important to this audience, I am also an alum of this very law school right here. And I love it that I'm back. And I see so many friendly, familiar faces, including, my some of my professors that I hope I do them proud today, and in general. I am a lawyer. I did not practice in the area of criminal law, but I find myself doing a lot on the Public Safety Committee, and I am the legislator who has, for 2 sessions now, championed the no-knock warrant ban legislation. So that's why I'm here, and I've been working closely with Knock First Minnesota on that.
Thank you. Father Daniel Griffith.
Great. Great to be with all of you today. Great to be with Representative Hollins and Sean on this panel. And I've been a faculty member here, a faculty fellow, for 10 years. I serve as a Wenger Family Fellow of Law, and since early September, the founding director of the Initiative on Restorative Justice and Healing, a new initiative at UST Law that seeks to name and help heal harm that comes from institutional and leadership failures, racial injustice, and also societal polarization. And just in introducing myself, the 2 areas that I'm going to look at, I'll answer the broader questions and more specific questions, but I'll be coming at the answers through the prism of Catholic social teaching and also restorative justice. So Catholic social teaching seeks to promote a more just and humane social order. and really concentrates on the common good, which is defined as the sum total of conditions that brings about human and collective flourishing. And one of those important conditions, or two of them, are law and policy. And so to look at law and policy, asking the question, is human dignity being promoted? Is justice being attained? Are unjust social structures need to be called out and replaced by more just and humane social order? And then finally, the two principles that come to mind are the preferential option for the poor and vulnerable and solidarity. In terms of if folks who are the purview of no-knock warrants, and we'll get into this question, if they disproportionately are people of color, which the data shows, then that is not justice. That's the perpetuation of injustice. So that's just kind of a teaser, if you will, in terms of kind of the prism through which I'll be looking at it, and I'll get into restorative justice in a minute.
Thank you. And then Sean Webb.
And so I'm a managing attorney with the Hennepin County Public Defender's Office. I am not an alum of St. Thomas, but I have taught here for almost a decade, teaching the misdemeanor defense externship, which is basically a public defense externship, trying to cultivate as many future public defenders from the USD class as I possibly can. And I'm going to be coming at this from the perspective of somebody who's practiced as a public defender for over 18 years and have seen no-knock warrants used in many of my clients' cases and talked to my clients about their experience being on the other side of that door, on the inside of that house or the inside of that apartment where a no-knock warrant was being executed. And sharing my thoughts on their experiences, but also my thoughts on how that should be part of the broader discussion about whether these warrants are in society's best interest and whether or not there's something that we collectively want to be supporting the continued use of.
Thank you all for those introductions and for being here. So to kind of launch this conversation, we want to start by looking at what's going on the state level. So I want to point this question at Representative Hollins because, as she noted, she has kind of championed legislation working to limit and eventually ban no-knock warrants in Minnesota. So Representative Hollins, could you just talk us through the legislation that you helped pass during the last legislative session, and then also talk to us a little bit about what you're working on now?
Yeah, absolutely. So last session, we brought a bill to ban no-knock warrants except during a specific set of crimes that had been committed. And when we talked with stakeholders, and in particular law enforcement, that was not regarded very well. They were not excited about that legislation, and so we really worked with them to, I can't think of a better word than water it down. Basically, it got watered down to be virtually nothing. I mean, the one thing that we did get was that you could not use no-knock warrants in a situation where there was simple drug possession, which is a lot of the no-knock warrants are used to recover marijuana. So I think when we looked at some statistics, and there was this enormous amount. It was like 50,000 no-knock warrants since the early 80s that had been used just to recover marijuana, which is kind of absurd if you think about it. And if it's enough that it's intent to distribute or sell, we're really talking about large amounts that you can't get rid of within a 30-second or 15-second period that you would use in a regular knock and announce warrant. So we did get them eliminated for that usage, and then we created a reporting requirement so that we could collect some data on how no-knock warrants were being used around the state of Minnesota. And so that part of it I really am proud of, because there was almost no information about how these were being used. And everybody said, well, we don't use them that often, but we had no statistics to back up any of the information that was coming to us. And so I don't know if you all were able to see it. I think MinPost did a great article that really broke down where they were used by county and police department, who they were used against, so a racial breakdown as well as a gender breakdown of who they were being used against. And we're really hoping by the time we get a full year's worth of data, we'll be able to see those success rates, like was it actually effective? Were they useful? And also harm rates, how many people were injured in the taking of that. And realistically, I mean, to your point, I don't think we're going to be able to measure all of the harm, because there is like emotional trauma that goes along with somebody breaking into your house. And so I think it was a good step in the right direction. Now this session, we brought I think, 3 days into session, Amir Locke was killed. And so that really reignited the conversation, and I frankly had a lot of angry community members reaching out to me saying, you screwed this up last time. This wasn't good enough, and this is on you. And so I took it upon myself to work again to create some legislation that tightened it up, and really worked with a lot of my colleagues who are prosecutors in figuring out how best to come at this particular issue. And we decided that it didn't make sense to list out specific crimes, because some of those crimes aren't defined when police are doing investigatory work. It's not, you don't get charged until after the fact. One of the crimes was first-degree murder. Well, first-degree murder doesn't get charged usually when police are doing those investigations and executing search warrants. It gets, they get charged after the fact. It's just a homicide investigation leading up to it. So we decided taking out the specific crimes and really creating an exception that was more political in nature than it was policy-driven. And it was political in nature because there were a number of our colleagues at the legislature who were not comfortable with the idea of a complete ban. They told us, we're scared if there is a person in danger in the house that the police wouldn't be able to get in, or if there's a hostage situation. They kind of came up with these insane reasons that law enforcement would need to get in. And really those reasons are covered by exigent circumstances, wherein a law enforcement officer does not need to get any warrant. If there's a hostage, nobody goes to court and says, hold on, hostage, I need to go get a warrant for this situation and make sure it's done properly. If we know somebody's been taken hostage, we are able to simply enter that residence and recover that hostage and prevent active harm from happening. Unfortunately, there was a lot of pushback still with the idea of a complete ban. So we created an exception that really enumerated those exigent circumstances in which it would be appropriate for law enforcement to try to get a no-knock warrant. And I am slightly disappointed to say that even with these exceptions that we created, we still weren't getting the support that we wanted from the legislature. And so what we've done now is amended the bill. As of last night, actually, we amended the bill to be a complete ban on no-knock warrants, and are pushing forward with that to have some of these really hard conversations that absolutely need to be had at the legislature, and that legislators frankly need to have with their constituents, because there is this misunderstanding of how they're being used and who they are being used against. And we believe that if we're going to force the conversation from a political perspective as opposed to a policy perspective, we need to be all in on this. And so as of last night, it was amended. It passed out of Judiciary Committee, and now it is in the General Register, which means it could have a floor hearing. And so we're going to be working with community groups to try to push the Speaker of the House for a floor hearing to have these really difficult conversations in a public forum. Because as a legislature, we're supposed to be responding to what the community is asking us for, and they're asking for a complete ban. So I'll stop there. Is that good? Okay. Thanks.
Perfect. Does anyone else have anything that they want to say about the state before we move on to Minneapolis?
I would just comment, I came to the same conclusion in terms of really digging into the data in terms of the state, and also the effectiveness or lack of effectiveness of no-knock warrants, and the real question of being officer safety. Now, may there be circumstances where, in some cases, evidence is more able to be preserved. Yes, there may be some circumstances, but from a proportionality analysis, in terms of the cost of lives, damage to property, and everything else that the data shows, from a proportionality standpoint, it wouldn't justify it. In terms of officer safety, there is no, the data backs up that the traditional knock and announce or announce and knock is in fact effective and more safe. And so as Representative Hollins was speaking, and I was thinking, man, I wish she would have taken one of the courses I taught, because we would have had fun. But as she was talking about that, you have to get over that political hurdle. And I applaud her efforts, and I hope the Minnesota Catholic Conference will be united in this approach as well. Obviously, public safety is important, but it has to be backed up by evidence. It has to be backed up by data, and it just isn't in the case of no-knock warrants from the research that I did.
And I guess the only thing I would add, and what I really applaud the representative on getting, was that data collection piece. Because prior to that piece of legislation, all we had was anecdotes. We had law enforcement anecdotally talking about these warrants were used infrequently, and these warrants were used in very serious situations. And even in just the short window of data that's been collected, I believe, since about September through maybe the end of January, we're seeing that these are used much more frequently than it was anecdotally being let on. And we're also seeing that when they are used, it's not the homicide cases. Though only about 7% of the no-knock warrants were used for homicide investigations. It's not even necessarily aggravated assault cases. Only about 15% of them were in that category. The largest percentage was in drug investigations, about 35%, or in property offenses, burglary offenses, which was about another 20 to 25%. So when we're looking at this, I think it's very important that we are starting to collect that data, because ultimately that is what's going to allow the public to make an informed decision about, from a policy standpoint, do we support these? And I might have a very strong position on that, but I think for everybody to be able to make that informed decision about where they stand on this, we needed that data. And before your bill was enacted, we didn't even have that data. And so I think that's the one thing that I think has been the most beneficial, even if this legislation last session and the legislation this session don't get us to perhaps where the three of us might want things to be from a policy perspective. At least we're going to be better equipped to have those meaningful conversations as a society, and to allow people to make informed decisions about where they stand on that issue.
Thank you for that. I also want to move to the Minneapolis level, since we've been talking about the state level. So in Minneapolis specifically, there's been a lot of changing policy. So most recently, the current policy enacted by Mayor Fry is that there is a moratorium on no-knock warrants. Now, I put air quotes around that because it limits no-knock warrants, but it does not ban them. It allows them in exigent circumstances. More recently, the mayor has come out and said that in the next few weeks, we should get some sort of language on a new policy that limits them. So we don't have the specific language yet. What he has said is that it will limit no-knock warrants except for exigent circumstances. It will still allow nighttime raids, but require that police officers wait 30 seconds before entering the household, and for daytime raids, that they wait 20 seconds before entering the households. So I want to start with Sean Webb. How has the current policy or the changing policies in Minneapolis impacted your work?
So while I know that there's been proclamations and announcements, I will take my skepticism a step further than perhaps you're taking your skepticism. At this point, there is no official policy. And so even from that basic level, we don't have the specifics of even what the mayor is proclaiming that he is going to make a policy change on. So it's hard to evaluate what this change is. He's already identified several large exceptions, several large areas that are not going to be included in this policy that until you have the details, it's hard to really make an analysis of, is this a meaningful change? Even if we go into this assessment with the assumption that it is going to be an attempt at making meaningful change, as a policy, something that's instituted by the mayor or instituted by the police chief, that policy can be changed at any point. That policy can be amended. That policy can be disregarded. There is no effective teeth to that policy other than what they self-impose. And so I think that looking at policy fixes for this rather large systemic problem are really looking at Band-Aid approaches to what probably needs to be more of a systematic, structural change in how we're approaching use of these types of warrants. And so prefacing it with that, because there is no definition of what the policy is going to entail, I don't think that there has been much of any change in how the Minneapolis Police Department is using no-knock warrants. We don't have specific Minneapolis data for the time period since the mayor has made the announcement that he's going to institute this policy change. So we don't know if there's been any less use or less, or if the police are seeking them less than they were prior to this announced change in policy. But if we look at the data that we do have, Minneapolis police use no-knock warrants extensively. We look back over the last 6 years, they're averaging about 150 of these no-knock warrants per year for the last 6 years. And so we know that this is a tool that they use extensively. We know that this is something that they're using frequently. And I guess we'll have to wait and see once we know what the policy entails and how it's enforced, whether or not this policy is making any meaningful change or not.
So for all of you, whether it's citywide or statewide, what changes to a policy or what policies would you like to see?
I would like to add something, I guess, to what Sean just said, and it kind of goes to your question, which is Amir Locke's situation and murder. Amir Locke's murder was a perfect example of why we need statewide policy and not piece by piece, because that was a warrant that was issued by St. Paul and asked Minneapolis to execute it. So it doesn't actually matter, and then it went back to St. Paul to see if they wanted to do a no-knock or not a no-knock. And I mean, the confusion between the different jurisdictions, especially when we talk about municipalities that are close together, and there are so many of them in our metro area that are governed by different law enforcement agencies. I think it is a perfect example of we need something that is unified across the entire state of Minnesota, so there's no confusion, because then it ends up being different municipalities pointing fingers and saying, well, we didn't say you had to use a no-knock warrant, Minneapolis, and Minneapolis saying, but you signed off on the no-knock warrant, and it goes back and forth. And as a person who represents St. Paul, and I love my city, it's really convenient for them to say, well, we haven't executed a no-knock warrant in 6 years. And it's like, yeah, but you gave permission for Minneapolis to do it. So does that really mean you're not culpable in this situation? So I think that, for that reason alone, we really need to look at something that is consistent across the entire state, for the benefit of all people. And also, when I spoke to some law enforcement, they said having it be piecemeal is more confusing for residents as well, because then they don't know who is knocking or who is, knocking down their door. If I move from Minneapolis, where I'm like, oh, I know the police will definitely knock and announce first, and I move to Roseville, where they definitely won't, that's confusing for me and puts me in a situation of danger. It also puts law enforcement in a more dangerous situation, because people are going to respond accordingly depending on what their expectation is. So, yeah, that's my end of that.
So just to follow that kind of theme, another thing that the data that has been collected has shown that a large portion of these no-knock warrants are being used by multi-jurisdictional task force. And so that just exemplifies or compounds the problem that Representative Hollins was just talking about, where now you're not only, it's not Minneapolis executing a warrant for St. Paul and who's actually in charge of deciding whether or not it's a no-knock warrant or whether it's a knock and announce, but now it's a multi-jurisdictional task force where there might be officers from 4, 5, 6, 7 different police departments or law enforcement agencies involved in that task force. And who's in charge of making that decision? How's it made? Is it based on where the warrant is being executed? Is it based on, the state agency versus a county agency versus the city police department? And so I think that the need to address this on a statewide level is just exemplified because of the prevalence of their use by those task forces. And I think that that's another example of why this is something that shouldn't be piecemealed, and it shouldn't be a policy that can be pronounced but then withdrawn, and it shouldn't be something that is going to have, there's 45, 47 some odd jurisdictions in just Hennepin County. We shouldn't have 47 different policies on this. We shouldn't have 47 different ways that this is being applied and interpreted. So I think that that's just another example of why a statewide addressing of this needs to be had. Specifically to the question as far as what additional things would I like to see in a policy, I certainly think that a requirement that the officers executing a no-knock warrant be required to not only have body camera, but also to be rolling that recording from the point where they arrive on the scene through the execution of the entire warrant. Right now, not every police department, not every jurisdiction equips their officers with body camera. They certainly don't. Not every jurisdiction equips all of their officers. But I think this is a situation, these are a circumstance where making that a requirement across the state is probably justified, because these warrants, the way they're executed, does create substantial risk to both the individuals who are potentially the targets of that warrant that's being executed, to people that who are not the targets, the Amir Locks of the world, but also to the law enforcement. And having a body camera recording requirement would at least add a layer of transparency to what was or wasn't done, how the warrant was or wasn't actually effectuated. And I think that would at least add an ability of a layer of accountability, because if we are able to objectively look at how these are being executed, whether the policy is being followed, whether the statute is being complied with, then we can have a more meaningful conversation about what the additional changes might be, or how we can more effectively and more fairly effectuate the use of these warrants when they are necessary.
And I would just very briefly add to that the exigent circumstances, they're always going to be an opportunity to be exercised. And so that is always an avenue that can be pursued when the circumstances warrant it. And I don't want to anticipate, I know a couple of questions down the line, but I think the significant racial disparities in this area, in a state already beset by significant racial disparities across multiple categories, from education to home ownership to income, and now we see, relative to the population, 7% of the population is African American, 10 times that. 70% of these are executed on African Americans. And I think of the situation in Illinois when they were confronted with the significant disparities with regard to the death penalty. It led the governor to ban it based on that on that alone. And I think until you can really dig into the underlying conditions that keep producing these significant disparities in our state, I think that very much is a basis to argue for a ban, in addition to all the other reasons that have been given.
That actually leads right into the next question that we had for you all. So as we've talked about here, we know that based on the legislation that Representative Hollins helped pass, it's now mandatory for agencies to track and release data on the use of no-knock warrants in Minnesota. And the statistics that Father Griffith cited just now are exactly right. Since September of 2021, when the legislation was passed requiring tracking, we've seen that more than 70% of people targeted by no-knock warrants in Minnesota are people of color. So this is a question for our whole panel. Could you just discuss how this issue of no-knock warrants intersects with issues of racial justice, and kind of at the same time, how that impacts broader conceptions of community safety and community trust?
I'll jump in. Just looking at the statistics, as a state, we have a systemic racial injustice problem. The percentage of the population, like the father said, approximately 7% of the state population is African American, yet about a third of the state prison population, and depending on which county you're looking at the data, potentially 50 or close to 60% of the individuals being prosecuted in criminal court are African American. And so whether I can identify all of the causes for that, it doesn't take an advanced statistician to realize that we have a dramatic disparity problem. And so I think that the data that we've now collected on the use of no-knock warrants is just the next example, or a more stark example of that disparity that exists throughout the criminal justice system, and throughout how we have historically chosen to police our communities. And I think that the larger public safety implication is that when we're focusing all of our resources on such a limited population, or limited percentage of the population, one, it's going to drive up the percentage of that population that's criminalized. But two, it's going to not focus those resources on other populations that in all likelihood are committing offenses at the same rate or in the same percentages as the population that we're focusing on. So we're driving both an over-criminalization of the population that's being focused on, but also an I don't want to use the word under-criminalization, but we're not seeing all of the crimes, or we're not addressing the crimes that are being committed by other populations that aren't receiving that hyper-focus. And I think, stepping back even further, that then leads to this distrust in the system, and this distrust of law enforcement, and this distrust that people are going to be treated fairly. And I think when that happens, then it makes it so much harder for any of the attempts at meaningful change to be effective. Because if there's distrust from the very beginning, that's why we then have to take the steps to make sure that we are forcing that transparency, that we're forcing that data collection, so that we are able to show what people are rightly skeptical of when we're talking about trying to make meaningful changes, that we can show that they're needed, or that we can show that the changes that have been enacted are at least taking some steps towards that goal. And so I think that while the no-knock warrant disparities are stark, I don't think that there's anything particularly unique about them in Minnesota criminal justice.
Go ahead.
Yeah, I think that as Sean was saying, the further eroding of trust. I recall in 2001, our late friend Tom Johnson, former county attorney of Hennepin County and president of Council for Crime and Justice, when he was in that role, initiated a STOP study. And it found back then, and everyone could self-report the different police departments throughout the state based on race. And the findings were very clear throughout the state. 3 times more often African Americans were stopped, 3.5 times more often they were searched, but 1/3 less often did they have contraband on them in relation to Caucasians. And this goes to your point. When those disparities are allowed to exist and in some cases continue to be perpetuated, this literally, to use Tom's phrase in another area, this creates an inversion of the moral order, of justice. And the effect that this has on communities is a cascading of harm, ripple effects of harm. I think of Amir Locke and the harm of the death of that young man. All of the ripple effects, the 4th of July where he won't be there, the friends who will miss him, the parents who I heard, when they were on TV grieving the loss of their son. And then you multiply that across all of the stories that people have experienced in Minnesota and elsewhere. And this is part of what we try to do with restorative justice, is to invite people to tell those stories. And to Representative Hollins, and she's probably already thinking in this way, in terms of legislation, to try to get folks to tell their stories of the harm that they've experienced in these circumstances. Because those real stories of harm can hopefully lead from restorative justice to transformative justice. And I think that's a real opportunity, as painful as that can be.
I think you both said it so well, and I don't think I need to go over the disparities that exist in Minnesota. I think we all are very aware of the racial disparities. The one thing I do want to note is when I looked at that data about who no-knock warrants were being used against and what they were being used for, it was this clarifying moment for me, because the majority of them were used in drug cases, right? Illicit substances. And the majority of them are being used against Black people, Black and brown. And yet, I don't know if you know this, I know that what's happening at the frat houses by the U, there are plenty of illicit substances. I know that around the lake houses by Lake Calhoun, there are plenty of parties with plenty of illicit substances. I know that in the party rooms of some of our large law firms, there are plenty of illicit substances when they get together. And yet nobody is using no-knock warrants against those individuals. We never see it happen. And I think that we absolutely have to call that out. We are taking the people who have the least among us, kicking in their doors, destroying the interiors of their homes, which are often rented, and they are left holding the bill for that. I mean, they often get evicted because of the destruction that happens from this situation, which creates another spiraling effect, and we won't get into the eviction situation and housing and how that impacts people's livelihoods, but there is a very real, very destructive situation happening here, and no-knock warrants are just a small part of the disenfranchisement of people of color within the state of Minnesota.
Thank you. And just one more question before we take some Q&A questions from the audience. This one is for you, Father Griffith. So could you just highlight how no-knock warrants impact understandings of human dignity and respect for life, both for the individual community members who are targeted, as well as the law enforcement officers who execute no-knock warrants?
Yeah, so again, coming from, we can come from a non-theistic standpoint when talking about human dignity, as was kind of the grounding for the Universal Declaration of Human Rights, or you can come from a theistic foundation, whether you believe that we're created in God's image and likeness and therefore what attends our nature is an inviolable dignity, Or, Immanuel Kant or others would say because we have reason, and that's universal. However you come at it, many people, there is strong consensus that we have an innate and inviolable human dignity. And what really flows from that are our natural rights, human rights. And so this idea of having these rights, well, when we see the degree of harm and the degree of disparities, and then the effect of that harm on self-worth and self-value, sometimes in some communities a real lack of hope or a inhibition of human flourishing and the generational harm that causes, that really does affect the sense of one's dignity and all that can lead to. And so I think it's a good thing, just from a humanistic standpoint, to say, let's craft policy and law that really takes into account the universal dignity of all people, and that all people would be treated fairly and with dignity. And then particularly, and I'll end here, with a particular focus on those who are already on the margins. Socioeconomically, it could be because of past racial injustice, whatever it might be, to have that preferential option, again, from a Catholic social teaching standpoint, because that's consistent with that universal dignity that we all have. And also with the officers as well, and to really encourage them to move to a place where we can move beyond perception. And I am so thankful for folks who put their lives on the line and very much believe in public safety and public health. But we have to also attend to the fact that a data-driven policy analysis is going to be best for everybody.
Thank you for that. So we're going to move into community questions. So if you have questions, write them down, raise your hand, and we'll collect them. So we have a couple that I'm going to combine into one question, talking about officer safety and some of the comments that you guys have mentioned about officer safety. And I want to give a little bit of background before I ask this. So we have some information about no-knock warrants. So nationally, between 2011 and 2016, or 2010 and 2016, excuse me, on a national level, 94 people died as a result of no-knock and quick-knock warrants. Of those 94 people, 13 of them were law enforcement. Closest to home is Officer Matthew Rittner, who was killed during a no-knock warrant in 2019. So kind of combining these and some of the information and questions about officers and safety concerns, this one here asks, what are the next steps to make sure that Amir Locke gets justice and that officers getting held accountable for their actions?
I'm happy to jump in on this. So I think Amir Locke getting justice, I don't know what the answer is to justice other than to never have these sorts of things happen again, right? There's no way to right a wrong or to correct something when someone is killed. That's a very permanent situation. With regards to officers being held accountable, I had a really interesting conversation with a chief who is in support of banning no-knock warrants. And her point was, the officer who shot, who was put in the front of that, that no-knock situation, often they don't ask to be put in the front of those no-knock situations. A chief made that decision and said, we're going to execute a no-knock warrant, and okayed that and said, you're going to stand in the front. And it really, this really changed my perception of asking for accountability for that particular law enforcement officer, which is to say, she told me, I think chiefs are putting their rank and file members in harm's way by asking them to execute no-knock warrants and putting them front and center in a situation that is nerve-wracking, that is high stakes, that is terrifying. And you see somebody who reaches towards a gun, and the first thing you do is instinctual to protect yourself. I'm not saying it was right. It definitely wasn't. But it changed my thinking on how to hold that one law enforcement officer accountable versus holding the system accountable and holding the chiefs accountable for the decisions that they make when they go into these situations. Because we can keep blaming the person who shoots, but the reality is they're taking orders from someone else, and it's a very hierarchical situation there. So I do think we need to kind of rethink where we're putting this blame and restructure how we want accountability to look. So yeah, I'll just end there.
I'll jump in because I completely agree with Representative Hollins on this. Holding accountable isn't necessarily that officer. It is holding the system accountable, because that officer, that officer who fired the shots that killed Amir Locke, he almost certainly had nothing to do with requesting that warrant, with signing off on that warrant, with deciding what role he was going to play, or even if he was going to be involved in the team that was executing that warrant. And so looking at how do we really make meaningful change, making that officer the scapegoat doesn't make meaningful change, doesn't further that conversation. It demonizes him, and whole separate conversation about whether or not any of that is justified. But it deflects from the systemic process that allows this to happen. And so I think, how do we hold the system accountable? We hold the system accountable in no-knock warrants the same way we hold the system accountable in any other time that they do something that's improper, that violates people's rights or violates the public trust. And the way that we do that in criminal court is we suppress the evidence that was gathered. And yes, that might mean that somebody who would have been charged with a crime doesn't get charged with a crime. But that's the way we hold the system accountable. That's the mechanism to condition the system to not violate our rights, to not violate what society has said we want to have happen from our law enforcement, from our criminal justice system. And so I think that needs to be part of the conversation about how do we enforce, how do we have accountability. And as a state, we've done that, and we've done that in the not so distant past. We have done that with the legislation that was enacted, I believe, in 2017 regarding electronic tracking warrants. And part of that statute lists out the conditions for when those warrants are required, and it specifically says that if these conditions exist and a warrant is not sought properly, that the evidence can't be used against the individuals in their criminal prosecution. And so I think that's how we enforce, or how we enact accountability, by having something similar to that in hopefully the next iteration of legislation addressing the use of no-knock warrants.
The other thing I would just add is that this really flowed from the war on drugs. I mean, this is where it was initiated, as was noted at the beginning of the program. And, this is the progeny of a failed policy that has had untold damage and harm in its wake. And I think for that reason as well, and for a myriad of other reasons, it does, I think, in reason, call for an end to the practice.
And so just in the interest of time, this question is just for Athena Hollins. What confidence do you have that a full-out ban will make it through the House, Senate, and actually make it to the governor's desk?
Zero. I have zero confidence. I hate to say that. I don't even have confidence that it will make it through my own DFL delegation caucus. I'm not entirely sure. I know the governor is in support. I've had conversations with the governor. So if it came to his desk, I absolutely believe that it would be signed on, but I don't think that it has very much momentum in the Senate, although we were working with the Gun Owners Caucus to try and push that a little bit, because Second Amendment rights are also being called into question and in some ways, violated in this situation.
Perfect. So this, I think anyone can answer. You probably only need one person. So given that the common, and I'm really bad at reading handwriting, common view is that police may need to enter immediately to save a hostage or a person in danger, what can be done to clarify when there are exigent circumstances and not a warrant situation? So I think the question is, what are warrantless entries versus times where you need a warrant to enter?
I'll jump in and answer that. All of the most, what I will call the worst case scenarios that are used anecdotally to justify the use of no-knock warrants universally fall under that category of exigent circumstances. If there is a hostage, if there is a risk of imminent bodily harm to somebody, if police are looking for the suspect in a homicide, those situations there's already a huge exception to the warrant requirement where those actually wouldn't be the times when they would be needing to seek a no-knock warrant. So I don't think that there's as much clarification or definition to that. What I think is needed is really the education and the training piece of what those circumstances are. Potentially with law enforcement that are involved in those investigations, although I suspect that most of them are pretty astute about those circumstances of when exigent circumstances apply. But I think probably the more pressing educational piece is for the public, so that people can understand that when those circumstances are used as the justification for not limiting or banning no-knock warrants, that those circumstances are not circumstances where the officers would need to seek any warrant at all, let alone a no-knock warrant.
And we are running up on our last 5 minutes here, so I want to kind of hopefully end on a more positive note, maybe a call to action if we can. So a question for everyone: what are some of the steps that everyday people can do to get involved in the push for no-knock warrant abolition or reform?
I would say become informed. If you are a law student, do what Representative Hollins did and go into politics. I had a law student very talented, passionate, bright, and I encouraged her to go into politics because I could see that she would be tremendous as Representative Hollins is. So get involved, use your talent to advocate for a more just and humane Minnesota, and then call your representative. Lean in and write or ask for a meeting and make your voice known. If you're in a residence community, have an information night with regard to this. This is something that it occurs to me either at Our Lady of Lourdes or at the Basilica, where I'll be July 1st, is to inform faith communities with regard to these issues as well.
Yeah, and I would add, have conversations with people. Like, take the information that you got here, ask additional questions if you have them, but take that conversation to your family at large, because I think you'll feel some natural pushback from individuals, and it's great because it's an educational opportunity. Talking about the statistics, talking about figuring out where these are used and how they're used, and racial disparities is all really important. And when we have human connections and human conversations, I think we're a lot more likely to push people in a certain direction than we are when we just kind of, bang our heads against each other like we do in the legislature.
And I guess the one thing I would add, looking at this audience of lawyers and law students and law professors, use your positions in this legal community, because this is an issue that evolved from the criminal courts and evolved from our legal system, and we can all play a role in helping to solve this. We can all play a role in helping to make this a better, more just, more fair system, and we can all play that role regardless of where you're at in your career, where you're at in your education, because of the fact that you are in this legal community and you do have an understanding and an ability to navigate what might be a very difficult process for people without this education or this access to understand. And so take advantage of that. Be part of the solution in whatever facet that might be for you, whether you're a practicing lawyer, whether you're a law student, or whether you're a teaching professional. Because I think that this is something that, for better or worse, the collective we in the legal community played a large role in creating this problem. And I think it's going to take the collective we in the legal community to really meaningfully solve this problem.
Thank you so much. Thank you to all of our panelists. I'm sorry to our audience that we didn't get to all of your questions, but on your tables, there's a QR code if you want to get a link to the Community Justice Project's webpage. And if you have further questions, you can send those to us via email, and we're happy to get back to as many of you as we can. So thank you again, and thank you to the Murphy Institute, and thank you to all of you.